Hello, Toolboxers. Welcome to episode 309 of the Immigration Lawyers Toolbox podcast. It's another immigration court update, this time for, I think it's October 2023. Little backup, it's very important to know these cases could affect your practice, especially if you're in immigration court, crimmigration, and the like. It's always comes in really handy. This things that, Kevin Gregg talks about. We're really, at this point, a preeminent immigration lawyer. The great thing about immigration law is everything is so new and changes every day. And you could be a relatively young guy or gal, and you could like zoom past people that are famous in the field and know more about a topic. It just requires a lot of time and study. And not going to want to do that, but if you do that, you can make a name for yourself pretty quickly and be very successful. So it's an awesome field, ripe for disruption. And so as I'm scaling my practice, I see all the issues now that exist in the practice field and how difficult it is for clients to reach a lawyer and how the process to happen. And we're as I talked about in the intro last episode, which I just recorded a couple seconds ago. I'm doing these back to back to get these recordings out. But I'm doing these demos on all these different pieces of software and stuff to learn what's going on, not just forms and stuff, but AI things that are coming, upcoming people are coming for lead management, all this kind of stuff. And I'm learning so much. And I realize the difficulty it is to have a well-functioning law firm once you scale, because it requires so much work and study and fine-tuning that it drains you. But it's again ripe for disruption. If you're willing to go through it, you could do it. Now we're not going to talk about that practice management stuff here. Hopefully, I have a time in a couple of weeks to do that. But we're going to talk with Kevin Gregg, one of the best immigration lawyers in the game. I can say that with confidence. He's it there. Before he started, I want to remind everybody that our marriage green card course is out. Not as complex as reading federal litigation all day, but the practical side of helping a marriage green card case, especially if you've never done one, you've only did a couple, or we have a lot of students that have been practicing 10 years, but we go into the laws and we talk about tips and all this kind of stuff to get around stuff. And it's group camaraderie. There'll be office hours where you can talk with each other and get friendships from across the country, refer cases, have a shoulder cry, and all that kind of stuff. That's what the toolbox is intended to be for, to get you the best at what you do. If you're interested, email me at info@immigrationlawyerstoolbox.com. Also, I want to thank our wonderful sponsor, Serenade, who's been so supportive. Serenade is a all-in-one form software that's really cutting edge. It's a modern practice management software for immigration-focused legal professionals to manage their cases, clients, forms, billing, and much more, an all-in-one solution. We have the software at the firm where we are members of it, and the software is trusted by thousands of happy attorneys and paralegals who use it to save hours of time for both themselves and their clients. E-Immigration has really, really high ratings in immigration software on these review sites like Capterra. Best value, best ease of use, best support, just to name a few. With over 100 features across the platform, you can pick and choose that you like. I recommend scheduling a demo. It's the best thing to do now that I've been talking to a lot of companies. Even testing yourself is not good. You need a demo for them to tell you what's going on and educate you. It's like having a teacher. Visit their website, Serenade with the C that is, or email them sales, plural sales at serenade.com, or just give them a call, 1-800-617-4202. I think it's worth a shot to at least talk with them to see what's going on. Having said that, wherever you're watching this, listening to this, like, subscribe, leave a 5-star review. That always helps us, especially in iTunes or whatever the new iTunes podcasting thing is. All the information about to be provided here is not intended for individual legal guidance. If you'd like to talk with a lawyer, learn about law, schedule a time with the immigration lawyer, talk with them in private. Having said that, let's get the ball rolling and let's get the game started. Hey, everybody, you have our favorite Kevin Gregg here. We're going to do our regular discussion about, monthly court cases and the such. But I was talking with Kevin ahead of time. I'm like, what are the downstream effects of these big cases? And right off the top of his head, he's like, well, let's talk about it. So we jumped into the recording. Kevin, thanks for being on the show. You have the great podcast, Immigration Review. You cover every case essentially. But like going back in the last, and how long we've been doing it? It's like, how long? It's been over 2 years we're doing it? 3 years? I can't remember how long we started.
Three and a half years. Yeah.
So what are the downstream effects of these cases? Like there's the NTA case where I'm like, this is the crazy that like all these NTAs are incorrect. There should be like massive amounts of cases going back to court, all that. Are we actually seeing that happen? Because I don't deal with these cases. I don't see like in practice. What are like the consequences of these big decisions?
Oh, hi, John. It's good to be back on our monthly talk. After I answer your question, which I'm happy to do, we'll jump into the October cases that I was interested in. But before I even do that, I must note that I believe you just introduced me as your favorite Kevin Gregg, which I appreciate, and you've got some excellent guests on your show. But I'd be remiss to say that actually, not even what you speak. To call me your favorite Kevin Gregg is actually very specific, because there is another immigration attorney, Kevin Gregg, Kevin C. Gregg. So for you to call me your favorite Kevin Gregg of the two of us, very much appreciate. Kevin C. Gregg, wonderful guy.
Hey, Kevin C. Gregg. on Facebook. We've chatted, we've commented on
He's
stuff. So much love to
he's
Kevin C.
great.
Gregg. I think
He's
he's
great, but
California too, right?
he is. He's great. It's Paso Robles, and great guy. But for you to say that I'm your favorite Kevin Gregg for all time, I mean,
That was a Freudian slip because I didn't realize I said that. So I got to see the recording. But Kevin C. Gregg, we love you too as well, and you're expecting to come up in the podcast. So you can randomly talking about you.
You should have Kevin C. Gregg on your show because he can talk great stuff about USCIS, especially and what the consulates are doing. And then you should also already say though that you've already called me your favorite Kevin Gregg,
Yeah.
Kevin A.
I have to break it to me.
I'm sorry about that for Kevin C. Your question's a good one. It's a complicated one. And the podcast kind of what's going on with the deficient NTAs that started first with the 2018 Pereira decision. And my podcast kind of tracked everything that was going on with it. My podcast starts in May of 2020. By that point, Pereira had, of course, been issued, and all of the circuits and the BIA had issued these decisions that were tethered to everything. Okay, fine. The notice to appear is non-compliant. It doesn't have all the required information, but everything is fine because the immigration court cleaned it up with a subsequent notice of hearing. And then once my podcast got going, very shortly after, the Supreme Court issued Nis Chavez, which said, at least for the stop time rule for cancellation of removal, the notice of hearing is meaningless. That doesn't cure a deficient NTA. And from there, it was off to the races. And since Nis Chavez, it's come up in lots of contexts, and it's pretty much universally known now with the circuits, and the BIA has admitted that, for example, the clock doesn't stop for cancellation of removal or voluntary departure if there's a deficient NTA, and assuming no criminal activity, even with a removal order. So you have these people who were not eligible for cancellation of removal, say, 15 years ago, because they had only been in the U.S. for 5 years, but now they are. And in matter of Chen, the BIA recognized that, yeah, you might have a grounds for a motion to reopen now that they're cancellation eligible, provided you can show prima facie case for approval. Now, the clock never stopped if the NTA is deficient. That's one context. The other context, the standard context where this stop time rule is the standard context. The other context, though, is what do you do at the beginning? All the circuits have held that notice to appear is not jurisdictional, but that it is a claims processing rule, and it's a mandatory one, but it's one that non-citizens can waive if not timely brought up. What is timely? That's a question. And we're starting to coalesce around, like, timely is at the pleading stage, or timely is before removability is established. Not quite sure what timely is. It's probably before an appeal, I'll tell you that much. But then if there is a timely assertion, what do you do with that? Quite frankly, I don't think the BIA knows. They issued matter of Fernandez, but nobody's happy with matter of Fernandez because they don't really say how DHS can cure this. They say, like, if it's brought up, the IJ has to deal with it, but they don't really say how the IJ deals with it. We know that the IJ, him or herself, can't deal with it. It's got to be DHS. But DHS, trial attorneys don't have regulatory authority to issue a notice to appear. Only ICRO or USCIS officers or CBP, pretty much everybody in DHS except OPLA has authority to issue an NTA. Yes. So what ICE trial attorneys are trying to do, and this is just me reading between the lines, is because of the bureaucracy that is DHS and what a pain in the butt it must be to try to, like, go to some ERO officer and be like, can you please issue a new notice to appear? ICE has been amending the NTA with an I-261, but, like, you can't amend, in my opinion, and in the motions I file, and under the regs and the statute, I think I'm right, and I'm not the only one arguing, you can't amend a case initiating document that's deficient and that doesn't satisfy the statutory definition of a case initiating document with another document that presupposes the existence of a proper case initiating document. And I-261 is really this, like, amend the charge of removability, add a charge of removability, amend a factual allegation. It's not to cure what is a incorrect NTA. And so, as the dissent in matter of Fernandez said, the only way to do this is to file a new NTA, but you can never file a new NTA when there's already an NTA. So the DHS would have to take back the NTA, which by definition means proceedings are terminated. So like you got to terminate. And the BIA issued a confusing amicus, in my opinion, that I'm not quite sure what they were saying, an amicus invitation. And they seem to be saying to me, we're not sure what we meant in that matter. Fernandez, can you guys help us? So that's currently pending. The third large context where there's movement on the deficient NTAs is actually the most exciting to me. It's in the in absentia motion to reopen context. And that's where the circuits, at least 4 circuits, at least 3 circuits, maybe 4 circuits, have flat out said that if the notice to appear is deficient, and if a in absentia motion to reopen is then filed, like the IJ's got to grant it. The BIA, the IJ's got to grant it. That's the 3rd, the 4th, the 9th, and I'm not sure who else. The 5th, it gets a little more complicated in the 5th and the 11th, and I'm sure I'm missing a circuit. Oh, the 1st circuit too. But it gets a bit more complicated in the 5th and the 11th. But like that's essentially what's going on, and that's because of the very specific motion in absentia motion to reopen statutory text itself is tethered to the definition of an NTA at INA section 239. And so because of that very specific statutory language, kind of what happened with 212H, because of like the weird way the statute's written, you got to reopen these cases. And if that's the law, especially in the 9th and the 5th circuit, where most of this has happened, and the 5th circuit has since walked it back. But if that is the law, I mean, tens of thousands of in absentia motions to reopen since 1997. Now, the BIA has already correctly, in my opinion, said that none of this applies to pre-97 orders to show cause, because the statutes and the regs are all different. None of this really applies. I believe my understanding, the Supreme Court has taken up certiorari on the in absentia motion to reopen issue, so there should be another decision. A 3rd deficient NTA decision should be coming, I think this term or maybe next term. So we're getting a new decision soon, and it's going to be big. And I don't know how it's going to go. And I'm not sure if I'm happy as an advocate for non-citizens about it, because like you've got a pretty good situation in the border circuits, even the 5th to an extent, and certainly in the other circuits. As an advocate for non-citizens, I'm not sure I want that to change. On the other hand, Pereira was 8-1. Nish Chavez was 6-3. You've got Justice Gorsuch because he keeps writing these things. And the NTA, the in absentia motion to reopen statute, it's pretty clear.
Yeah.
I just think, forget about advocacy. Like, I really don't understand the counter argument. I'm not convinced at all by the 5th and the 11th circuits rationales. It seems like they had a solution and they were looking for a logic to get there. So we'll see what happens.
I would have just expected more chatter on the Facebook pages and the listservs, and by the lack of it, I'm like, are lawyers not challenging this? Are they not aware? Or just as something everyone knows, not talking about? There must be like some conversation, but I was not seeing it happen. But you're saying like, yeah, you're doing these cases, you're filing, especially in absentia. I worked removal for 2 weeks when I first started as an immigration lawyer. In the 2 weeks, every case was in absentia. I'm like, there's like a lot of in absentia or removal orders that I ran into. Yeah. So I'm like, there's got to be a ton of people.
Well, yeah, but I mean, by definition, almost like the in absentia is like, people might not even know about it. They definitely don't have attorneys, the vast majority of them, or else, they would have appeared. And so, like, it might just be the case that there's all these in absentia sitting out there, and these people are just living in America.
Yeah.
And like, they're not going to an attorney, or they're not,
But then it's like, I watch TikTok, like all these lawyers advertising, they're dancing VAWA without going back to their home country. They're doing all this kind of stuff. Like, why not? I mean, it's kind of hard to explain, but hey, if you have an in absentia order and you want to reopen it, you potentially terminate your case and you're married. Like, it's kind of hard to sell and explain, but
it's wonky stuff and it's confusing. I don't do the lawyer Twitter stuff, so I'm not sure of what those attorneys are. It'd be hard to do a dance and point to the corner. It says in absentia and then point to this side and say deficient NTA. I think you might lose people, but with the terminating proceedings, the other thing is to what end? There are some, if you terminate proceedings and ICE doesn't restart them, maybe that's good. Maybe you have a weak case, but like you also lose your employment authorization if you have a pending application. I'm not sure people want that. To me, especially if it's non-LPR cancellation or asylum. Even like those are difficult things to win. What's worth it to
That's
you? Do you
true.
take termination? It's hard to
Well, we have
make that
a
decision.
similar case we picked up where they got married U.S. citizen. The case is like administrative close or something like that. And so we have to open up, terminate the case so we could we get the I-130 approved, then do adjustment USCIS. But once you reopen it, they lose the work authorization. That's like, oh man. So for the client, it's like there's gonna be a gap there. You probably once you file for adjustment request and expedite on the work permit, but there's like a 2 or 3 month gap with no work authorization that's gonna happen.
Yeah, I completely understand where non-citizens are coming from and their concerns for that. I'm also I, I understand it as their attorney, and that is something. But I just personally, I'm pretty unsympathetic to it. I mean, you're putting these people on a path to a green
Yeah, there's
card.
a future. Yeah.
They're here with a removal order. They're lucky they're here in the first place.
Yeah.
Like you got to eat that. I wish that the framework was different, but I mean, so that's to say, like, I mean, I'm sympathetic, but like,
Yeah. Oh, the reason I
there
bring
are
it up is
bigger
just something I have
things
to
at play.
study. I have to study because they're like, do I keep my work permit? I'm like, I don't know because I don't do court stuff. So I have to research. I'm like, oh wow, they're gonna lose it because the basis of the C8 or whatever the kind of visa. I can't remember what it was. Another attorney's handling it, but I had to research. I'm
Yeah.
like, oh, it's interesting that they lose it temporarily until they get a C9 EAD based on adjustment.
Yeah, I mean the bigger flaw is that we're tethering work authorization of the United States to anything. To be honest with you, like
Yeah.
why why have a shadow population in America without work authorization? And if the idea is that if you give them work authorization, it's going to create a bigger pull. I'm not sure it's possible to create a bigger pull. So like that ship has sailed.
Yeah.
So why are we having this underclass who's jumping through hoops to have work authorization when we definitely want them to work? But
That
that's a
underclass aspect to me is like destructive of our civilization having an underclass like that. So
oh my god, oh my god, absolutely. With the canaries in the coal mine for taking away um rights.
mm-hmm. So
And
having
now
said that, that's a big intro. Sorry, go ahead, but a big intro to
drum roll. No, but look at Thurassigum. Like now it's Supreme Court precedent that there is an underclass of people with constitutional rights. Like people, at least, and I haven't read it in a bit, it's been a couple of terms, but like if you've come to the border and you're in America, but like you just got here, you're less due process rights than somebody else, that's a slippery slope. If you're in America, the Constitution applies. If you're not, you're not. I mean, but I'm not Justice Alito. But it's a canary in the coal mine.
yeah,
They'll try
definitely.
it. They try it with non-citizens first.
There's a new thing that starts. I always see what the government does is they get immigrants first and test it out before they're going to unleash on us. And there's a new thing where I can't remember something about forcing like facial scanning and biometrics on like all this
Yeah.
kind of heavy duty Snoopy stuff so that the government could do and track like aliens that are in the United States. It was like next level kind of Terminator style or like in 1984 style kind of stuff. And I was like, oh man, they're gonna practice the system on them. They're gonna unleash that hell on us.
It's scary, and I've had these conversations with removal defense attorneys too. But here's the counter: like I have never met a non-citizen, and quite frankly, I've never met an immigration attorney, if they're being honest, who wouldn't take an ankle bracelet,
Yeah,
facial scanning, all that over immigration prison. I
yeah.
mean, I got a non-criminal person subject to reinstatement right now in prison. He's been there for 10 months. He got no criminal history at all. Like literally anything besides immigration prison. So
Yeah.
I like the problem is that like once you start doing it, you do it to everybody, even the people who aren't flight risks or dangers. So
Mm-hmm.
that's a problem. And then of course the slippery slope into US citizens. But like I as an immigration attorney, like I would jump
Yeah.
on surveillance with my client's approval over them being in immigration prison. So it's a hard one. It's
It's
a
like,
hard
do you want this horrible thing? You want this more horrible thing? It's like,
yeah.
it is what it is. Yeah. Well, thanks for coming on. Let's jump into some cases. October, it's November we're recording this, but what happened in October? It wasn't that much deal flow going on or case flow going on, I'd say.
It's been slow. It's been so slow that last week or 2 weeks ago I had no cases, and luckily I had interviewed Dan Lawton. It was recommended to me by an attorney. Of I oh, geez, late, by an immigration attorney mentor. Dan was recommended to me by an immigration judge mentor of mine. He had just wrote a book about this falsely accused IRA, Irish Republican Army member who did not kill this prison guard and who was convicted of it. And it's a whole thing. And so I had to push that out though, because I had no cases from the circuits. So it's been a slow October and kind of slow November too. But I got 3. They're kind of they're criminal based, and I'm glad we could talk about the NTA stuff because I can be pretty quick about them. First is Peskin, the Attorney General of the United States out of the Third Circuit. And Mr. Peskin was convicted of DUI while under the influence, and he was a green card holder, and ICE alleged that, and then he was on many drugs, to be honest with you.
Just
DHS,
for one DUI, they don't usually, if a green card holder, kind of let it slide, will you?
Yeah, I think he crashed, and 6 counts merged into one, so like a lot of substances.
Yeah.
And DHS alleged that that it's not a crime of violence. It's only one conviction. They alleged that he had violated law. It's a conviction for a law relating to a controlled substance, and the Third Circuit said no, because this DUI offense, the jurors don't need to agree what controlled substance was in his blood. So it could be alcohol.
Oh.
Still a crime, but not a violation of a law relating to a controlled substance. Could be something else that maybe is in Pennsylvania's list of controlled substances and not the CSA, but really alcohol was probably the one. And so that's interesting in and of itself, but more interesting to me was the logic the Third used. For example, they said that the text shows that it could be any substance, that juries need not agree, even though the jury instructions require that the jury list a substance. And that's usually used to find that it's divisible, that the statute's divisible, and you can look, for example, to the substance he was under. But in this case, the Third said no, they don't have to agree what to write in, because the statute itself is way more important than the jury instructions. So too, the fact that the government charged Mr. Peskin as being under the influence of, I don't know, let's say it was cocaine, doesn't matter, because it doesn't, what the prosecution charges can't change what the conviction statute actually requires. And that's an important thing to remember, and you love to see it if you're advocating for non-citizens in these decisions, reminding the courts that what the government charges can't change what the minimum conduct that the statute requires.
Those are just allegations at the end of the day. Whatever the prosecutor's saying, they're allegations. They're not.
Well, yeah, but even if he pleads to it, even if the government alleges that he was under cocaine and he agrees in his plea agreement, I was under the influence of cocaine, it doesn't matter if the statute could have been convicted if he was just under alcohol. And the fact that the government is specifically alleging cocaine is only of little importance. This is all really coming from the Mathis decision, the Mathis peak, where the Supreme Court says, if we're looking into divisibility, we're trying to figure out what the elements of the crime are. If all else fails, then you can look at the charging document. If all else fails. But if the statutory text answers it, if the statutory text and the case law answer it, if statutory text and the jury instructions answer it, if it's answered, what the government is alleging is irrelevant. And so it's important to remember. The Mathis peak is the last resort.
Do they typically go after people for controlled substances if they're using it as opposed to selling it or something like that? Do you run into that for users?
If you get convicted, absolutely. Absolutely. If you get convicted, if you don't get convicted, if you don't get convicted, you're not removable as a green card holder. If you are inadmissible, if you admit to it, or if there's reason to believe you engaged in drug trafficking. But for the aggravated felony trafficking conviction, for the aggravated felony trafficking removability, or for the violation of a controlled substance removability, requires conviction.
Okay, interesting. Good stuff. A lot of educational stuff there. Thanks for your attention.
Crimmigration is a hornet's nest, but I like it. I enjoy it. Once you get it, I always tell interns, like, once you get it, like, you're in. Like, there's no going back.
Well, good stuff.
Next,
Anything else?
oh yeah, matter of Brathwaite. I'll be quick on this. This decision follows the Second Circuit's decision in Brathwaite v. Garland. Same case. The BIA came back many months later, probably over a year later, and said, "All right, fine, Second Circuit, you're right, we're wrong." They had no choice. And said that an accepted motion for leave to file a late notice of appeal under section 460.30 of the New York Criminal Procedure Law makes a conviction not final. So in layman's terms, they usually have 30 days to file a notice of appeal in criminal court, really any state's criminal court, usually.
Yeah.
If you don't file it, your conviction is final. And if your conviction is final, then DHS can try to remove you based on your final conviction, if it matches the definition of removable offense. But in New York, this 460.30 statute under New York law allows people to file this late filed notice of appeal a year after that 30-day deadline expires. So you essentially have a year and 30 days to file your appeal. And the Second Circuit describes this essentially as an appeal of right, and like it seems like they're accepted all the time by the New York Appeals Court. Now, I guess they don't have to accept it, and I think if they didn't accept it, then you'd have the final conviction. But if they do accept the appeal, not decide it, I don't believe, read Brathwaite, if they just accept it, then you don't have a final conviction until the appeals court decides. That's what the BIA just agreed with in Brathwaite, matter of Brathwaite. So essentially in New York, and I'm not saying play the game, but essentially you have a year and 30 days where you could potentially not have a final conviction. And so if you get a client who got a conviction 7 months prior and they didn't appeal, like you got to get on that, have them hire criminal counsel, file that appeal in New York, because otherwise, and that'll be if it's accepted, automatic termination of the removal proceedings if it's tethered to that conviction.
People got to listen to the show, man. You're getting it here. It's good information. Yeah.
Got it. And in a footnote, the BIA is like, this might apply to other states too. I mean, but they say it definitely doesn't apply to New Jersey, which I find amusing. But it's based on the statutory schemes for criminal appeals in those jurisdictions, and using the arguments accepted by the Second Circuit and now the BIA in the Brathwaite cases are your guide to arguing that your state's criminal procedure for late filed appeals, except New Jersey, makes it such that it is an appeal of right, and so the conviction isn't final until that late file appeal is decided.
Good stuff. Well, thank you for that. Anything else, or was the last case for today?
Final thing, because it allows me to talk about the Attorney General, who's a bit missing in action in immigration at the moment, and has been for most of his term as Attorney General. But in the 11th Circuit decision, Kamukai v. U.S. Attorney General in October, Mr. Kamukai was an he never naturalized. He should have. I think he was, yeah. Oh, yeah. He never naturalized. That's how these always go, right? The person delayed naturalizing and then they commit a crime and they're screwed. Yeah. And his crime was an aggravated felony. So he's removable. And an aggravated felony bars him from asylum. He's from Sierra Leone. I think he'd come in as a refugee. But if you don't get 5 years in prison, it's not a particularly serious crime for withholding of removal purposes. And that's what happened here. He didn't get 5 years in prison. Mm-hmm. But the immigration judge and the BIA held that it was a particularly serious crime for withholding of removal purposes because of the crime. But what the agency what they did wrong, said the 11th Circuit, is that they failed to consider Mr. Kamukai's mental health. Whether or not a conviction makes a non-citizen dangerous such that it is a particularly serious crime requires consideration of that non-citizen's mental health, if present. And that wasn't the case until Attorney General Garland came around in matter of BZR and overturned the BIA's matter of GGS decision and said, no, 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 we're going to consider mental health in the particularly serious crime analysis. So that is literally the one decision that Attorney General Garland has issued that wasn't simply vacating what Attorney General Barr or Sessions did. And here's its real consequence. Potentially letting Mr. Kemukai, letting an immigration judge, a judge, consider the facts, consider whether his mental health makes him less culpable, such that he can still apply for withholding of removal from Sierra Leone. So the Attorney General's decision at work.
You mentioned the name Jeff Sessions. I can't believe that Jeff Sessions was in charge of the UIR and making these decisions. It was kind of nuts.
Be careful. Well, if the former president becomes the current president again, it's going to probably be Jeffrey Clark, who was trying to overturn the 2020 election. Not to freak everybody out, but at least Jeff Sessions was interested in retaining the norms of the Department of Justice, as was Bill Barr. I'm not sure that some of the people that are being floated as Donald Trump's potentially future AG are quite so interested in those laws and norms that have been in the DOJ for 150 years.
Well, yeah, along with that, I mean, I haven't read the article. It's a New York Times article about their plans to just round up everybody and stuff. I don't think practically they could do it. If anything, he created more of a backlog during his residency. He was trying to deport more people, but ended up backing up the court. So more people are just backed up in here getting work permits a lot of times. So he did the opposite of like effect what he wanted to do. But wow, it's going to be they always say it's like the biggest election of our lifetime. This one, I was like, they always say that, but it seems like this one's gonna be it.
I'm getting pretty sick of dealing with like once in a century events.
Yeah, yeah, it's enough for our generation.
Quite a few.
Yeah. I always felt bad. Like 100 years ago, like imagine if you were 15, then when like World War I happened, then the Spanish flu came in, and then you got the Great Depression, then you go to war from 1913 to 1945, 30 years. So essentially, your lifetime, you're just seeing hell after hell after hell, especially if you're in like Europe or China or something like that. It's pretty bad. But that's some, people see some stuff in their lifetime.
No doubt it was worse 100 years ago for people my age, no doubt at all. But I mean, we could use a little less of this.
Yeah,
that'd be good for me.
Yeah, I hear you, man. I just got my business going, life's good. I'm like, yeah, let's keep the train going. I'm gonna live up this lifestyle some more. But our job is to kind of smooth out the lines, help people, and also help the government understand what systems there are. And these podcasts help a lot. There's people in the government listening to this, and they see the stuff that's happening. That whichever side they're on, if you're reasonable, like this doesn't make sense for anybody. A lot of stuff they're happening. So hopefully we could help open up minds on how the system is to have a better situation come out of it.
Judge Mimi Sankov in New York is the head of the Immigration Judges Union. The National Association of Immigration Judges is not a union anymore. And she came on my podcast last month. She agreed to, I don't think immigration judges could, but in her capacity as the president of the National Association of Immigration Judges, she could give me a little bit of time. So I think that was pretty eye-opening. Nice. Just within the IJ group themselves, they're fighting just to be able to speak through their union. And she talked about a bit what it's like to be an immigration judge, at least in New York. So
my apologies for not listening, but I didn't even know you did that interview. So that's definitely listened to. It was a month ago. It's like in October or something like that.
Yeah. No, I did that in October. She was gracious to give me her time. And I think she could only do that in her capacity as president of the National Association of Immigration Judges.
Does she have an opinion on what is the first I don't know, like to make constitutional courts instead of
Article 1? Absolutely. It's the official position of the National Association of Immigration Judges and the FBA and the ABA and ALA to make immigration judges Article 1 judges and take them from under the purview of the Department of Justice and the Attorney General. So she very much does have that opinion in her capacity.
Yeah.
As president of the National Association of Immigration Judges.
Because you practice in both UIR and federal practice, would having these be Article 1 cases significantly increased legal fees because you have to go federal procedures now, like because EOIR is kind of like whatever the judge wants. It's not the most formal kind of thing, but
Well,
rules
I
of
mean,
evidence come into play, all that kind of stuff if it goes federal.
I'm not sure if the rules of evidence come into play just because you're not, I mean, you don't become a federal court in the sense of an Article 3 or, court. It's like this weird thing, like a drug court or maybe a bankruptcy court where the federal rules do apply, or the drug courts. I do think that they're I mean, the bill would probably say more things than just this is now Article 1. It
Yeah.
would maybe answer some of these questions. I do think legal fees probably go up. I think that, but I think a rising tide raises all ships. I mean, it's not incorrect to lament the standard of practice sometimes in immigration court, and I
Yeah.
think that if everything becomes more official, then so too
Yeah.
does standard of
That's
representation.
true. It's very true because there's some like I mean back before this judge was the head of the former union. It was Judge Tabador in California in Los Angeles,
Yep.
and I was on a panel with her. It's probably like 6-7 years ago, and she straight up was like, "Yeah, I'm like amazed at the caliber of lawyer, like in a negative fashion that come before her. She's just blown away a lot of times, and unfortunately, you do see that a lot. It's just a hustle a lot of times."
Yeah, I mean, there's some great ones too, but and then there's really good attorneys who have a bad day. Don't get me wrong; it's
Yeah,
all sorts of things. But like the real bad ones, the factories, the ones who are working hand in hand with notarios,
yeah,
they bring the whole profession down. And then
big time.
you have DHS and the immigration judge looking at us with suspicion. So
You
I do think you have to rise everything, and Article 1 is the first step. I mean, if you on the flip side of that, to focus on DHS now, I mean, I'm pro sanction authority for the immigration judges. They just have to be able to sanction both DHS and the private bar.
yeah,
Got that statutory authority, but the regulations were never implemented as I understand it, because then INS balked at the idea that an immigration judge could sanction their attorneys. But if you have a courtroom where the judge doesn't have sanctioned authority over the attorneys that appear before her,
yeah.
then you've got a power dynamic that doesn't make sense to me in a judicial system. The judge has to have the ultimate power in court, whether you agree with the judge or not. And so
Yeah,
I
I'd
think
be
there's
more inclined to practice federal this kind of stuff if we had like that system where both parties, because even right now, I remember again when the 2 weeks when I practice and I hear other people like just contacting DHS counsel for a case to talk with them. There's times during Trump, like you can't even talk with lawyers to kind of negotiate something or like figure something out. This case mistakenly in court and shouldn't even be in court. Let's do a joint motion for termination. It at times it's hard to even find who to communicate with, or the person doesn't get the case till a day before. I would imagine if it's a federal kind of thing and Article 1, that'd be more professional about it. If you, I don't want to downgrade, but it's just the nature of what's going on. I get a million cases themselves, so they're overwhelmed. But maybe that would smooth things out, the difficulties of just practicing in this area.
I think it would be. I'm sure that there would be negative aspects of it too, but I think that on the positive would be great. The other thing though, like reaching out to DHS, don't get me wrong, I do it all the time and I've had good experiences or no experiences, but like, what is their incentive? You know what I mean? Like, it's not like criminal court where you can reach a plea deal and your guy does like 6 months in jail or pays a fine. Like,
Yeah.
it's either deport or not deport. Like, there isn't really much room for negotiating in the immigration world. And I think that's one of the problems there. And I think that's one of the reasons that DHS sometimes just doesn't return our call. They're just like, whatever, let's see if he's credible or not.
Yeah.
Let's do it.
Makes sense. I'd hear that. Well, thanks for coming on. I appreciate it. I mean, the end of the year's coming. By the time this gets posted, it's probably gonna be December. Any plans on closing off the year or what's going on for remaining 2023 for you?
I got an individual hearing in Miami in mid-December, which it looks like the government's going to remain open. So we'll do that very interesting individual hearing, and parents coming in for Thanksgiving, which is in a week from when we're recording now. So pretty excited. How about you?
Same here. I'm revamping my business a lot, changing it, making it to more formalized, creating systems for scaling, all that kind of stuff. So a lot of my time is just spent like just figuring out how to run a business in a different way and different campaigns and business development plans I have. So it's really neat because I'm really going more on the business side. I'm going to talk about on the podcast more, but new ideas I have to really expand our scope and ability to handle cases. So that's the game plan. Once I set up, start doing it, then I'm going to talk about it more publicly. But that's the goal, like set up all these systems in this remaining of this year. So to really shore up, have more case types, have more team members, and just a flow of leads that are coming that are bigger than what I did before without as much personal involvement. That's the goal.
All about the systems.
Yeah, man. Yeah, man. That's how you grow, and not you could relax for 2 seconds instead of a 1 second relaxation. I get, but that's the key. He says, between having a family and running all these businesses is hard, and I realized I got to find people that are really good and do good training and systems, so I could replace that portion of myself that's formerly handling stuff. And it's kind of forced my hand into this, and like because I don't have enough time to do it all. Or else I'd probably stick to what I'm doing. A lot of things to evolve a lot of times, or most times, human beings got to be forced into it. And that's what I'm going through. I'm like, I just can't do as much video marketing as I wanted to build a business. So I got to find alternatives that don't include me making videos all the time. Even though I love making videos, it's just I don't have the bandwidth.
Keep doing those little cartoon things where you put your heads on. I like those. Those ones are good. Whatever you do, don't lose that one.
I gotta get back into it.
I like those ones.
Well, Kevin, I appreciate it. If you want to reach out to me, first of all, I got the Immigration Review podcast. I was talking to my friend who's got a podcast too, and he went to his website that like ranks podcasts and what they're doing with their analytics. I didn't know it existed. I didn't even take out the name, but I'm like, oh, let's look at mine. And I was like, okay, I'm like top 2%. Scoring is like 38 out of 100. Like Joe Rogan has 65. I'm like, that's pretty good, 28 or 38. And I'm like, put my number one competitor, Immigration Review. I put it. We have the same percentage, top 2% of podcasts.
That's great. That's
yeah,
great.
Exactly. Yeah,
we're friendly. We're friendly.
So I'm like, okay, we have the same exact scores, which is interesting. And I'm good. We interplay with each other, so it's all good anyway. So
as long as we stay above Charles Cook.
Which actually I just
he doesn't do it that much. He doesn't do it regularly. You got to do it regularly.
I think he used to. I remember I first started looking at podcasts. Listen to this. He's got charisma. And he likes talking about it. He's really open. I listened to a couple. I think one thing that technically happened is he changed name of his podcast for some reason, and he got hit in iTunes and just disappeared off the face of iTunes. But I think he published it a different way. But I just did an interview with him. It was released today. It's mid-November right now. Going over what happened with 21 Savage. What was the deal? And he tells most of the stuff. He said there's a certain part of it confidential, obviously, but he spills out like all the information with the musicians and the media talking about it all wrong. So he was really breaking down what actually happened. He wasn't like a visa waiver overstay or these other things. So it was very interesting. Good, worth listening. I'm gonna make a clip of it so everyone can listen to it too. I'm gonna post it on the Facebook group. So you'll catch it. Very interesting stuff.
That wasn't even planned to bring up Charles, and then you just did an interview, but you just smoothly got it in there for your next episode.
That's a hardcore immigration lawyer like yourself, man. That's he's really into fighting immigration law.
No, I'm just joking. But I just want you and I to be the top 2 podcasts.
Yeah, we got the top 2. I think some of these bigger firms are trying to get it on our stuff, but what I think at the end of the day, our passion is going to carry. But they're good too. I mean, if they do good work, they do good work. But I think our audience, you probably go to these events and they come up to you, people, listeners come up and talk with you. You know how it is. The relationship is next level. Doing these kind of things.
It's cool.
Yeah. Well, good stuff. Again, if we want to reach out to you, what is podcast Immigration Review? Email is, if you want to give an email, I'm not sure.
Oh, of course. Gregg at kktplaw.com, KGREGG at kktplaw.com.
And a little known thing, you also do consulting with the immigration lawyers who need to contact you to go through a case. You do stuff like that too?
Yeah, and I'll always respond to an email. Off the top of my head, I can't do research for free.
No, like the paid kind of like consulting on the side.
Well, that as well. But honestly, like I'm always happy to just respond to an email, and I have a lot of these cases have stuck in my brain, so I like to think that I can offer some things with just a 5-minute email. So I always, I'm honored that people would reach out to me.
Well, that's very kind of you. Thanks so much for coming on the show, Kev. I appreciate it. So we'll have you back in next month before the holidays get really heavy. But if I don't see you, happy Thanksgiving, first and foremost. So good seeing you, bro.
You as well. Bye.
Bye-bye. Have you ever felt that the road to establishing a successful immigration law firm is riddled with unexpected obstacles and setbacks? I've been there, and I'm here to tell you, you are not alone. Picture this. My wife, then girlfriend, and I had just landed for a vacation only to be greeted by a voicemail that changed everything. In an instant, once the plane landed, she lost her job. The very one job that was supposed to support us while I launched my own solo immigration law firm. Suddenly, our financial cushion vanished, and I was thrust into the high-stakes world of entrepreneurship with no safety net. Despite a slow start and a discouraging lack of leads and referrals, I remained determined to build a law firm that provided a 5-star client experience. After countless hours spent researching, watching, and implementing marketing strategies with mixed results, I eventually began to see my firm's revenues not only surpass my previous revenue and salary as an associate, but double it. Today, I run a successful law firm with a team of associates and support staff, and I'm the proud founder of the Immigration Lawyers Toolbox magazine, podcasts, courses, workshops, and more. But my journey wasn't easy. I made many mistakes, wasted time and money, and wished I had a mentor to guide me through the challenges. Although I was fortunate enough to find a few peers who offered support, I couldn't shake the feeling that there had to be a better way. That's why I decided to be the change I'd wish I'd seen. This month, I'm thrilled to announce the launch of the Immigration Lawyers Toolbox private mentorship and peer group. This exclusive group is designed to bring solo and small firm practitioners in a monthly, private, and intimate setting to openly discuss business strategies, share successes, even exchange invaluable tactics that they wouldn't share anywhere else. By joining this premium group, you'll not only benefit from my hard-earned expertise, but also forging long-lasting relationships with like-minded professionals who are committed to elevating their practices. Space is limited for this game-changing opportunity. If you're ready to make a real, lasting impact on your business, simply email me at info@immigrationlawyerstoolbox.com. Again, that's info@immigrationlawyerstoolbox.com. And I'll send you all the information you need to get started. Don't miss this chance to transform your immigration law firm and reach new heights of success.